You got to answer. See this gentleman right here? He's taking down everything that you're saying and I'm saying, as well as recording it. So you need to push that microphone up to a little. Push. You don't have to lean over. Push it up. There we go. Just try to speak as loudly as you can. Okay. All right. Do you understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford your own? You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Runyon could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena.
Yes.
You understand that trial you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state. Now, you're entering these pleas under what we call a judicial diversion. That means because you have no prior criminal record that you qualify. State has agreed that you should be placed on post-trial diversion. That means I'm going to be putting you on probation for a period of 2 years. This plea that you've handed me is going to be putting that record in your file. If you stay out of trouble and do everything you're supposed to do, then at the end of this 2 years, you can apply to have your record expunged. If you are successful in your probation, do you understand that expungement means wipe clean, in other words. But do you understand that if you violate the terms of your probation, then these will come back and they will become permanent convictions that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes.
You also understand that under the statute, you could be brought back and re-sentenced within the range of punishment for the offense for which you're pleading. You understand that? As long as you stay out of trouble, do what you are supposed to do, you won't have a problem. You understand that? All right. You understand everything I've explained to you so far?
Yes.
You want to plead guilty according to this agreement. Is your decision to plead guilty today voluntary? Anybody forcing you to do this against your will?
Nobody's forcing you. Okay. I'm sorry.
We twist that around to make sure you're paying attention. So you understand this is all done voluntarily on your part. You're not being forced to do it against your will, correct? All right. Still going to ask you to speak up a little bit. Now, you understand that I cannot accept your plea. Well, first of all, you understand you're pleading guilty, and if you plead guilty, the court of the state may ask you questions about these offenses. And if you answer those questions under oath and on the record, and in the presence of your lawyer, your answers can later be used against you in the prosecution for perjury. We determine that you were found that you were lying under oath. You understand that?
Yes.
Then are you in fact guilty of this charge of two charges of reckless aggravated assault? All right, tell me what happened. What took place? Why are you pleading guilty to something?
Don't see the stop sign. Don't see the stop sign. I go there, don't see the stop sign.
Yeah.
You're also used part of the going too fast for conditions and not see the stop sign and collide with another car, correct?
All right. Anything further from the state about this?
Just your honor, he was driving an 18-wheeler at the time, and he was going down Highway 46 in the intersection of Highway 13. He was going above the speed limit, and he completely failed to stop at the stop sign and hit a lady and her son, T-bone him as they were traveling past 46.
Right.
Also, this court, I'm sure Mr. Runyon's told Mr. Romero this. This is a 100% sentence, so if he was to violate his probation and be sentenced to serve, by either you or one of our judges, it's district of service.
The offense for which you are being found guilty are actually the which you're pleading, because we were deferred the finding of guilt for 2 years if you're on probation. But you understand that if you were to have to serve that sentence, you would have to serve 100% of that sentence. Understand that? You understand everything I explained to you so far? Are you satisfied with your attorney services?
Yes.
Feel like Mr. Runyon's done a good job of representing you competently. Mr. Runyon, you know of any reason you should not enter this plea?
I do not, Judge.
Any further from the state? Renato Omar Romero, docket number 2025 CR 30 of the Houston County Circuit Court, on your plea of guilty to count 1 and count 2 in each of those cases, ordered that you be placed on 2 years probation under the 4035-313 for post-trial diversion. The fines are waived plus court costs, and they will run concurrently. Counts 3 and 4 dismissed as part of this agreement. As stated, it was the arranged one offender, but it is a 100% release eligibility. And probation is being transferred to Florida if the probation department approves.
Thank you, Judge.
He needs to see the probation. What else did you have, Mr. Runyon?
Judge, on page 6 of the docket, Michael Varner.
Is that a Stewart or?
It's a Stewart County case.
Oh, let's let our clerks transfer us. We got Ms. Donna here. Ms. Donna. And who was your client again? I'm sorry.
Michael Varner, V is in Victor. Last case on the docket, I believe.
All right, what are we doing in this case?
Judge, on CR 38, Mr. Mosley and Mr. Varner's been guilty of misdemeanor vandalism in count 2. Count 1, the aggravated burglary, will be dismissed. It'll be on 1129 probation. That'll be concurrent with 2024 CR 48.
Varner, raise your right hand. Let's push you on the road.
You solemnly swear from the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your full name for the record.
Michael Varner.
Mr. Varner, you're here today on a 2-count indictment. You've heard your lawyer talk about what the agreement is, but have you seen or been shown a copy of the charges, talked about them with Mr. Runyon, you and he discussed the range of punishments you're facing as well as any possible defenses you might have? Well, it's indicated that you want to enter a plea of guilty to count 2 and have count 1 dismissed. You understand you have a right to plead not guilty to all charges and to have a speedy and public trial by jury.
Yes.
You understand you would have the right to have a lawyer at trial and have one appointed if you cannot afford your own. You understand that if you went to trial, you would be presumed to be innocent until such time that the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and therefore it would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Runyon could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that by entering this plea of guilty, you're waiving your right to a trial or to an appeal. All I'm going to do is, I'm sorry. You understand if you went to trial, you were found guilty, you can have an appeal and have a lawyer appointed to help you with that appeal. You understand that all I'm doing is to prove what you and your lawyer have worked out, that you're waiving your right to a trial. You understand that's going to result in a misdemeanor conviction, and that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained to you. Do you want to plead guilty according to this agreement and waive your right to a trial?
Yes, ma'am.
You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty.
Yes.
You understand that if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if I determine that you're lying under oath.
Yes.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand I have to have facts to support a finding of guilt in your case. So are you guilty of this misdemeanor vandalism? What happened?
So much from porch and I vandalized her up.
All right. Anything further necessary for the state?
No, Your Honor, that's correct. As far as restitution, we did not hear back on restitution from.
All right. Are you satisfied with your attorney services?
Yes.
You feel like Mr. Runyon has done a good job of representing you competently?
Yes.
Mr. Runyon, you know of any reason we should not enter this plea?
No, Judge, but something we did not discuss. I just want to be sure he's clear his probation that he was on, that he violated, starting over. He's not as part of this agreement. And if we need to reset this case today, if you'd contemplate that, I think the court would reset. But your probation starts today that you've been on.
The only thing I is, since I've been incarcerated, my family relocated to a different state, and so I'll be homeless out here. I need to transfer. My wife and son, they've been in the same house at the same job since June when I got arrested, and so they're in Michigan.
We've already discussed this. He's not eligible for a transfer, but he's indicated to me in the past that there's a transitional house here in Guilford that you can go to. So that's where we stand with the transfer out of state. It's just not eligible at this time.
I have no job or no way to pay for that.
Would you rather go ahead and just serve it out in jail?
How long would that be?
Well, it's 11/29 with credit for time served, so I don't know how long it would be before they said you had served it. When did you, he was on probation or had a sentence before?
Yes, it's before the new charge.
How long you been in jail?
June 28th, last year.
Last year? Give him credit for time served, he served his sentence.
It's true.
Would you like to just serve your sentence rather than be placed on probation?
I don't know about the BOP though.
He has a 3-year sentence for possession of firearm.
Well, this one was gonna be served concurrently with what he had previously, which means he's gonna get credit for that time since June of last year, which means he served more than 11 months and 29 days. So this court finds he has served his sentence. He will not need to be placed on probation. We're gonna turn you loose and you go where you wanna go, except that you're on probation for a felony. You gotta adhere to those terms. Now, they've told me you're not eligible for a transfer, so as I've told you, I've said before, the only way you can get it transferred out of this area is to have the Department of Corrections approve a transfer to another state, and they have to be willing to accept it. So right now, we don't have that. So we're gonna show that you have served this sentence and that you are concluded with this case. Thank you.
Thank you, Judge. Thank you for calling me.
Mr. Atchison is here. We need to take that matter up. If we need Ms. Donald back here, don't we? All right, we're taking up a Houston County case again, but we are set for trial in this case, I think, next week. Is that correct?
Judge, I believe this is about 2 weeks away.
And Judge, the purpose of filing it now, we had initially set today's date for motions in this matter. However, based on the motion to continue to file on behalf of Mr. Cook, we don't have the forensic analysis back yet on the cell phone. That motion was initially granted by Judge Wallace. It took me quite some time to find.
What motion was granted by Judge Wallace?
The motion for additional funding to secure a company that could do the forensic analysis. He granted that motion, Judge, but it took me quite some time to find somebody AOC approved that would accept and take on the responsibility of analyzing that phone. We have found that now. I just don't have it back yet. And so I would be, I think that it would be a disadvantage to my client if we moved forward without that being complete.
All right, so essentially what you're saying is that the victim's cell phone is the one that you're talking about
That's correct.
in this case. And what is there on that phone that you think would be relevant to the trial, which is set next week?
Judge, the in and out phone calls, the messages between the parties, I think are very relevant. I think that it also, if nothing else, Judge, I think it helps us prepare a more proper defense for Mr. Cook moving forward as opposed to not having.
Wilkerson, you involved in this case?
The co-defendant's attorney.
She has Mr. Dashman.
And do you agree with what Mr. Atchison is saying?
I do, Your Honor. I've kind of been riding his coattails on this a little bit because my client is not court appointed and doesn't have the funding for this. So I've been kind of tracking along with Mr. Cook to be able to get the funding to get that phone done.
Have you gotten the funding approved?
I have just,
All right, so it's just you've not been able to find someone?
well, it took quite some time to find a company that would actually, I ran through, well, this is short, but I will say that. And they were the only one within this area that agreed to take it. I got a couple of times refused for,
All right, step aside, let me hear from the state.
Your Honor, to give you some context on this phone, Mateo Bazelon, it's his phone. Back in spring of 2025, I took his phone to Homeland Security. The issue we had was he had given us a passcode. It's an iPhone, but the passcode Mr. Mateo had given us would not work, would not open the phone. So I went to Homeland Security. I dropped the phone off there. They were able to break into it a little bit, get some data, but it was very limited. There were no messages between him. There was no messages at all, from my understanding. I've given that phone dump to both defense counsel. They weren't able to do a full extraction. They were able to get a few things off, maybe some pictures, but nothing like an extent I would take a phone and get a full extraction. Argument I'm saying is if the Homeland Security, U.S. Homeland Security can't get into this phone, I don't know who would be able to get into this phone. Another thing, I don't know about the relevance. The facts bring out the communication, and this has been testified to at the juvenile transfer hearing and prelim. The communication between Mr. Cook and Mr. Mateo Bazelon was all during FaceTime prior to this incident. I don't know if there's any way to extract FaceTime videos or messages in an extraction. So I don't know if we've been able to get any of the communication leading up to this event anyways, because it was all done via FaceTime. According to the testimony of, I believe, that the defendant, Mr. Cook, and the victim, Mateo, in previous hearings. So, Your Honor, I don't know if the company that Mr. Anderson is going to be able to get anything out of Mateo's phone if U.S. Homeland Security can't get into it. I don't know who can. I don't know if there'd be any relevance, because I don't know if there's going to be any messages leading up to this event that occurred. So I would ask you to deny the motion.
but just briefly, as follow up. What I was saying is accurate. Mr. Baldazon did provide a code to his phone, but I think that anybody familiar with iPhones knows that if you give the code, the phone should open. And so that leads into a different argument wherein I don't think he's gave the proper code. And if we're going to move forward on something, then I want to address every angle possible. That's a very serious charge, and I think that Mr. Cook is entitled to that.
Well, the charge against Mr. Cook, and I assume that Mr. Dasher, is attempted first degree murder, or attempted murder. And it's a Class A felony. There are other charges as well, but obviously the issue of what interaction has occurred between the victim and the alleged victim and the defendant is a big part of what the jury will probably need to know leading up to that. The biggest issue here is that there's been a court order entered by Judge Wallace to authorize the funding for this particular endeavor that you're in. I don't find there's any fault on the part of the defense lawyers in trying to get this, because I'm sure it is difficult to find a technological company that's willing to do that. And as Mr. Woodall says, none of us are sure exactly what's in that phone or what you're going to be able to get. But erring on the side of the defendant's right to present a competent defense, I have no choice but to grant your motion to continue to allow you to. We're going to set it the next term of court. You'll have that much time to get it done. I assume the state has a reciprocal discovery request so that if they obtain any of this information, you're.
I don't know if I'll file one, but I'll give one file.
So, understand that whatever information is on that phone, the state's going to have a reciprocal. I think, yeah, my calendar. And our next term of court is in December, right? This being a Houston County case. About, I showed that we have the State versus Dillon Ray Estes that set for the 15th. Is that still a go?
I'm not, probably a day and a half, just to be on the safe side.
So if we set this case for the 17th,
I'd say this would be a 2-day trial.
you think this one is a 2-day trial?
Three-day, 14.
So State versus Dillon Ray Estes, you're saying is a 2-day trial?
I would say a day and a half, yeah, just to be on the safe side, Your Honor.
Well, I mean, December is obviously the holidays, so. What about the 28th and 29th of December? In between Christmas and New Year's? Y'all not doing anything during that time, surely? Yeah, I say that at the risk that I'm gonna be referred to as Judge Burks Jr. or something. Because in January, I am back in Dickson.
Your Honor, I don't know if we have anything set for trial in Stewart County on that.
In
Thursday.
December.
Do we want
I've
to
given you the 8th and 9th and 10th.
see if we can do this use of those days? We just need to check and see if we have anything set. I'm not certain.
Why don't we set it for the 9th and 10th of December?
Good with that.
Yeah, I'm in a, I already have stuff set. Final hearing for
What day?
ninth, and it's been moved twice. Like, I'm fairly certain my client would maybe work. Okay. I get it.
Can we move the Dillon Ray Estes to the 8th and 9th and give you the 6th, 15th and 16th, and if necessary, 17th?
I've no issues with that. Do that.
All right. We need to, who is the defense lawyer in the Dillon Ray Estes?
That's Caroline Wright. Confirm with her.
Confirm with her that we need to move that to the 8th and 9th.
Okay.
Or the 9th and 10th, either one of those combinations. And we will put your case on 15th and 16th, and if necessary, the 17th. This is all in Houston County, right? Okay. Good thing I write my calendar in pencil.
Smart move.
Anything else?
Judge,
All right.
thank you, Your Honor.
Yep.
Cool.
I'll draw the board, Judge.
Thank you.
Please do. All right, we're ready to go back into the regular call of the docket for Stewart County. Mr. Flanagan, what do you have?
Judge, can you hear me?
I'm not hearing you. I don't know if you're muted on your end or if you got to turn your volume.
I'm getting an echo.
Can you hear me?
I can hear you. Can you hear me at all?
I can hear you now.
All right, Nina North Fleet, who's in the courtroom. General Allen and I are gonna go to a September date. We're still negotiating and hopefully have a resolution, but I don't know what that date is. Brooke,
That it just for possible pleads. I think we just need one more month, Your Honor.
You want to set it September what?
Is it the 14th?
September 14th.
I'm just waiting to hear back from some of the parents.
September the 14th.
And then if we don't settle it, we can set it for Your Honor.
All right.
thank you, Judge.
All right.
And
Anything
Miss
else?
North Fleet is there and she can leave, so
All right, let's go sleep. You're here, but you can leave.
thank you, Judge.
Anything else?
That's all.
All right.
Thank you.
Now we can get out to you.
Yes,
Okay.
Okay. Yeah, let's take those.
All right, first case on the docket is
That's last, he had some wait for him arraignment and plea of not guilty.
Mr. Flanagan, we can hear you, so you need to exit out.
Judge, if we could, their general speed.
All right, who did we call?
Mr. James Allen, first on the docket.
James Elisha Allen. Mr. Allen, you have filed a pro se motion apparently for a sentence clarification. Actually, you're saying motion to fix defendant's jail credits and for defendant's actual release date. There's really no way I can do with it. You were sentenced by Judge Larry Wallace, so I'm going to appoint the public defender to assist you in determining what your actual sentence credits are so that you can know when your sentence is expired or you've served your time. So they will look up those. Mr. Clemens is here. We're going to appoint him to step in and take over looking at your case to determine whether or not that you've served the amount of time that you think you have. Okay. He'll get you credit for everything, but he's going to have to look into that. So we'll put you on September docket just to make sure. Okay. September the 14th, Mr. Clemens.
Thank you.
All right, let's call the next case.
next case is 2024 CR 10 Kelly Babcock.
She entered a plea back in April of 2025, but we delayed the disposition to allow her to be furloughed to the Hope Center for a one-year program. And have you finished the Hope Center?
Yes, Your Honor, I have. I'm still currently in aftercare. I graduated June 9th this year. And I'm still in aftercare center affairs.
I talked to Mr. Potter, Your Honor. The state's recommendation would be just to revoke and reinstate her. She does have her certificate
Right.
today. You want her?
Well, she's already pled, so what we're going to do is, today was just for a sentencing hearing because you'd already entered a plea. So what I'm going to do is as a part of the judgment in this case, is to order that you be revoked to serve your sentence, but based on your completion of the Hope Center, not having any further problems, we're going to reinstate you back to probation. Okay? You did what we asked you to do, so we're going to give you that credit. All right. Good luck to you in the future. Do you want this back?
Yes,
Okay.
We can make a copy.
Huh?
Make a copy.
Let's make a copy and give her back the original. If you'll wait a little bit, though, we'll have your copy, we'll have your original back. Okay?
yes, Your Honor. Thank you.
Congratulations. We have inmate Jennifer Barber, but Susan here.
Next case is 2019 CR 33 Jennifer Barber.
And they have both females up. They're gonna do everything else first and then they'll bring the females up.
Here's next case will be Paul Dickson.
I'm gonna pass the Paul Davidson case until we can, I'm gonna review that file and I'll have that file. Let's go to the next one, which would be 2025 CR 5, State versus Joseph M. Duty. Mr. Duty, you're also wanting to clarify your pretrial jail credits. You're indicating that you don't believe that you received the appropriate amount of pre-sentence jail credits. Is that correct?
Yes.
All right, Mr. Clemens, I'm gonna have to appoint you to represent Mr. Duty to see if you can determine what credits he's entitled to. And I can't look at it and tell anything about it, but they're pretty experienced in this. Mr. Clemens is a good lawyer. He'll look into it. He'll let you know whether or not you are not receiving all of the credit to which you think you are. Okay.
Thank
you. All right. We'll set it for that September 14th day just to keep it on the docket. The next case is that one that we have set for 11 o'clock for a plea. Is that correct? On
Yes, Your Honor.
Then I'll move to 2025 CR 65 State versus Richard Gordon of Stevens. I'm sure Sonny Stevens was the attorney.
Let me see if she stepped into the hall. Second call, Your Honor, I'm not sure.
All right.
I know that she has circuit and Dickson. Oh, there you are. I'm so sorry. I've been zooming.
Your Honor, if you would entertain a second call, they're about to pull up emails and that's why I'm waiting on for reasons.
Put it on the second call. We're doing the inmates. Sorry. 2023 CR 6 State versus Robert L. Kaiser. We've heard from his attorney, Mr. White.
He's here, Your Honor. He just stepped in the hallway.
Okay. This is for a sentencing hearing.
It is. It can take a little.
All right. Mr. Kaiser, if you'll just have a seat, it'll take a little bit of time for us to get to you, so let's take up something shorter now. 2016 CR 60 State versus James A. Merriweather.
Your Honor, it's my case. Mr. Merriweather's here. He's got a violation of probation, which we'd like to plead to today.
Okay.
Have to vote to serve. He's
Mr. Merriweather, raise your right hand. Let's place you under oath.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God.
State your full name for the record. Mr. Merriweather, you are here today charged with violation of community corrections. I want to make sure you understand your rights. You understand you have a right to plead not guilty to the charge and have the state the state would be required to prove to the legal standard that you had actually violated your community corrections probation. You understand that you would have the right to have a lawyer, to have one appointed if you cannot afford your own, which I've done with the public defender. You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is revoke you to serve your sentence and give you credit for all your time. You understand everything I've explained to you. Do you want to waive your right to the hearing and enter a plea of guilty to the charge of violation of convenience and correct? Then I find you guilty, will need to be revoked to serve your sentence with credit for all your time served. Thank you.
And I have the jail credits. I'm gonna give them.
That's fine. Twenty 45, State versus Patrick Harden and Rogers. I think he's filed a pro se motion for sentence clarification.
Yes, Your Honor. This is a case, kind of similar, I'm guessing, to the two others I was just appointed to, except I've been appointed to this a while back and hadn't been able to make any progress on it. The situation is he's been revoked to serve a 2-year sentence, and he's got day-for-day credits, as far as we can tell. That's just about 61 days short, does that sound right, of having served the full 2 years. When I was appointed to this case, Judge Lockett Mash told me, well, get his sentence reduction credits, find out when his release date's supposed to be before battle. However, I haven't been able to get those sentence reduction credits. And when you look up his case on Tinfoil, the website that normally show things like sentence information, felony offenders, it's blank. It's got no start date, no end date. He tells me it used to have an end date on there, January of this year.
January 31st.
But then it went blank, and we can't figure out what to do. I'm at a loss. I've told him as soon as he's a day late, I could file a habeas, I suppose, but I didn't want to go that extreme. And if there was any better option.
So he pled to 2 years Department of Corrections on attempted aggravated burglary, 1 year on theft, and 1129 on vandalism. Is that correct?
That's right, John.
And that was back in November of 2024. So how about I just say that he has served his sentence and find that he is entitled to, I mean, he served more than 75% of his sentence, it seems to me. So
yes,
if he's been in jail continuously since that time. So why don't we put an order down that just says that his sentence has been completed according to his release eligibility?
That sounds good, Your Honor.
State have any opposition to that? Right.
Shall I draft that order, Your Honor?
You draft an order that says that the court, it came before the court for determination of whether he gets any jail credits that he wasn't entitled to, that I find that based on the sentence that was imposed and the length of time he has served, that he is entitled to be released.
Yes, Your Honor.
Thank you. Mr. Rogers, don't go back to the jail today and tell all the other inmates that you're going to get released just because you filed a motion, okay? 2025-071 State versus Martrell F. Seabury. Mr. Clemens, that's your case.
Yes, Your Honor. Actually, I have a settlement on this. Let me pass this up, please, Your Honor.
All right, Mr. Seabury, I've been handed a document indicating that you want to enter a plea of no contest or no contendere to count one aggravated assault on a first responder, a Class C felony, and you would receive a 6-year sentence as a range 2 offender, suspended to supervised probation, credit for time served, waive of any fines. You would have count 2 dismissed as a part of that agreement, and you get credit for September 1, 2025 until today against your sentence. Raise your right hand. Let's place you on the road.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record. Mr. Seabury, you're here today on a 2-count indictment. You've heard me go over what your agreement is, but do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand that a plea of no contest means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they step to the microphone and tell me what they say you did. And I'm going to use their version of those facts to find you guilty according to this agreement. You understand that? You understand, as I've said, that you can plead not guilty and have a speedy and public trial by jury. And if you did that, you would have the right to have a lawyer, to have one appointed, which we've done with a public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted. You understand that if you went to trial, you and Mr. Clemens could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand by pleading guilt or no contest, you are waiving your right to the hearing and to the appeal. All I'm going to do is approve what your lawyer has worked out for you. Do you understand that's going to result in a conviction that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime? You understand everything I've explained to you? You want to plead no contest according to this agreement and waive your right to a trial. Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there is a factual basis and that you are in fact guilty. Then I want you to listen as the state tells me what their evidence would be if you were to trial. Step aside. Let General Allen come to the podium, please.
Your Honor, the state would put on proof that on September 1st of last year, Corrections Officer Liam Allenez at the Stewart County Sheriff's Office was doing a bump check, got into an altercation with the defendant. During that altercation, the defendant fractured Mr. Allenez's orbital socket. I've talked to him. He is agreeable to this settlement. We had some witness issues with doctors. I think one of them was a contract doctor, not able to locate the trial. So he's agreeable to this settlement. There is no restitution. His insurance covered everything.
Mr. Seabury, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes.
Still wish to plead no contest.
Yes.
Are you satisfied with your attorney's services? Feel like Mr. Clemens has done a good job of representing you confidently.
Yes.
Mr. Clemens, you know of any reason you should not enter this court?
No.
Anything further from the state?
No, Your Honor.
Then Martrell Seabury on docket number 2025-071, upon your plea of no contest to count 1, count 2 is dismissed. If I do guilty, sentence you to 6 years in Tennessee Department of Corrections as a range 2 offender. That will be suspended to supervised probation on time served with credit for time served from September 1, 2025 until today. Fine is waived. We'll need to see the probation report. So we have Mr. Kaiser is one of the remaining cases, and then I believe
That's our 11 o'clock.
who, that's at 11 o'clock. Okay. All right. Let me run through then the rest of these cases that are on the docket. Hmm. Okay. 2026 CR 58 State versus Joshua Lee Hooper.
Restoration of voting rights.
State have any position regarding Mr. Hooper's petition and restoration of his voting rights? I'm sorry.
Defer to your honor.
Your petition does not contain the paragraph 4 of the petition, the form that's provided states that you should list all of the felony convictions, Tennessee and out-of-state convictions on that petition. That has not been done, although there are copies that have been attached of all of, apparently, copies of all of those convictions. I'm not sure that the Department of Corrections or that the Tennessee Bureau of Investigation would accept the form, considering the fact that you have not added all of those in there. You understand what I'm saying? On the first page of your form that you submitted, right here, it says list, I have the following felony convictions. List all Tennessee felony convictions, all out-of-state convictions that would be a felony under Tennessee law, and all federal convictions. It's blank. I know you've attached a bunch. Is that you that attached all of those convictions? Where did these copies of these documents come from?
He came by the office, got those copies from the clerk. He did submit to, I don't remember.
All right, I'm going to take this under. I'm going to have to look at this and look at the statute. So, raise your right hand. Let's place you under oath.
You solemnly swear affirm the testimony you're about to provide the truth, the whole truth, and that's what the truth shall be God.
Mr. Hooper, is all of the information in your verified petition for restoration of your citizenship rights, is all of that true and correct? Is that true and correct what you have filed? Is that, do you have any other convictions other than those that are shown there?
No, sir. I have some that were expunged, but I think they're still in there. I think all the charges I've had are in there.
Right. I'll take a look at that statute and then I will let the clerk know what I'm going to do. All right, thank you. Day versus Dorothy Martin. Ms. Martin, you filed a motion for sentence modification alleging that you were sentenced to 4 years at 35%. You have close to 2 years already served. You originally pled to these charges back in June of 2025, but you were revoked in February of 2026. Judge Locker Mash was the judge who revoked you to serve your sentence. When did she do that? I'm gonna move your case to October in front of Judge Locker Mash, since she's the one who revoked you, and let her look at it, and she may consider the fact that she will grant you your request. But for me to grant it, it would be changing what another judge has done in your case, and I would rather let her have that opportunity.
Thank you.
All right. What day in October? They'll bring you back in front of Judge Locker Mash. For 2019 CR 33, State versus Jennifer Barber. You're in the same situation. You pled out in front of Judge Larry Wallace, who revoked you to serve your sentence. And you were applied to the recovery court for the 23rd Judicial District. And by letter of November the 5th of 2024, they denied your application based on the fact that you have a possession for a conviction for possession of a firearm and commission of a dangerous felony in Montgomery County. That was a disqualifying violent conviction under the recovery court statute. So again, because Judge Wallace is the one who heard your case and revoked you to serve your sentence, he'll be here next month. And I will move you to his court docket so that you can have him consider whether or not to change what he had originally ruled in your case. September 14th. September 14th.
Thank you, sir.
All right. Twenty 22 CR 95 State versus Roger Wayne Hicks Jr. Mr. Hicks, you are here today because you have apparently filed a pro se. You're having issues with the expungement of your record. We're looking to see if a judge would help in getting this off your record, like promised by the county prosecutor when you took the plea deal for the case.
Yes, sir. I just feel like there's been a grave adjustment by the state on this case. This plea was set forth by the prosecutor, the DA, and signed off by a judge. And feel that's not a victim situation. It's been years of probation, crossed every T, dotted every I. Exceptional letters from the probationary department by itself and the program. Did everything right, but still,
You did everything that you were supposed to do, but Department of Corrections, TBI, which is the agency that says you are entitled or not entitled to expungement, states that under the statute, and there is a specific statute which they rely upon in giving a response, if the offense for which the person was diverted was a sexual offense, as defined under 4039-202, or a violent sexual offense, as defined by 4039-202, then you are not entitled to have it expunged, even if that was part of the agreement. Again, this was in front of Judge Lockett Nash, who took the plea, and you pled to soliciting aggravated statutory rape from a minor. So I'm going to move you to the next date that Judge Lockett Nash has, which would be the October the 5th, to give you a chance to since she took your plea, she may be willing to do something to help you to determine whether or not you should have some expungement. I don't know that she can, because the Department of the TBI is the one who's in charge of all the records. So we've sent them an application for that, and they've kicked it back, saying you're not entitled. So it's going to be up to her to see whether or not she does it.
I understand that the law changed after this.
It may be. Well, let's let Judge Lockett Nash, who took your plea, and she's the one who said you should have the right to have it expunged.
Yes, sir, because this has been authorized by a judge, DA, prosecutor, everybody.
Right. Well, she's going to take a look at it on October the 5th.
October 5th.
Right.
Yes, sir. Will I receive any documentation to remind me of this date?
They will not give you anything except a card to write down that date, but you need to be here on October the 5th.
I appreciate your time.
Right. Thank you. Twenty 2026-057 State versus Hallie Kanzler.
Your Honor, this defendant is currently in rehab. And the state plans to file a motion to revoke bond. We plan to she got new charges while she was out on bond. We'll probably set that for some time. We want her to complete the rehab, but we still have to address the new charges. So we plan to file a motion to revoke bond. So we just need to reset this matter. Can we set it for September?
All right, September 14th. Twenty 2025-067 State versus Aaron Miller.
Good morning.
Good morning.
Birch here on for Mr. Finley.
We just need one more settlement day. I do believe we are going to reach a settlement in this case. We'd like to set it for 12/7. We have not reached a settlement by that date. We will be setting it for 12 days.
December 7th. And you would just pass your motion to dismiss till that day?
Yes, sir.
Thank you.
2026-016 State versus David John Wood. Ms. Wong.
Good morning, Judge.
Good morning.
I have a conflict with the dates that were selected for this case. Town of Dover today. I've asked if we could reset that, and defendant actually called my office after I left on Friday, said to my assistant he didn't have a problem with this motion.
So November is Judge Turnbow. So Judge Turnbow is the judge who has it set in front of, and you're asking to continue it from that 10th. Who's prosecuting a speeding charge out of the city of Dover?
So we were in court. It was determined that it would actually be this one.
Oh, so you're the prosecutor. Okay.
Today.
Congratulations.
Thank you, Judge.
Well, I don't have a problem continuing it for you if that date's not appropriate, but I would say you need to get with Judge Is there another date in the month of November that Judge Turnbow has court dates? Why don't we just set it on his, VOP day, and that way set it for trial, it shouldn't be that long.
The 30th.
What day is that? November 30th?
That's perfect.
All right, November 30th.
Thank you.
2025 CR 22, State versus Dewey, Preston Robinson.
For your honor, that was my client. State Senator Judicial. Put that on second call, please. I appreciate it.
Twenty 2024 CR 46A, State versus Johanna Singletary, Mr. Clemens, that was your client.
Yes, Your Honor. Secretary. Your Honor, with your approval, we'd like to request that this be reset to Your Honor's next court date. She's in progress getting the drug court in Montgomery County.
Right.
And that's what she worked.
December 7th, is that right?
December 7th.
December 7th.
Thank you.
All right, thank you.
December 7th.
On the 2025 CR 31B, Benjamin Sogsog, is that the one that's at 11 or is
Yes,
that
that is Bagel to Brad, our companion case.
11 o'clock? 2023 CR 103, State versus Billy Russell Tomlinson. Mr. Clemens, this is your case. It's for status today.
Yes, Your Honor.
Your Honor, this is one of the home improvement fraud cases that we've been tracking along with the appeal of that statute. And speaking with Mr. Clemens today, what we'd like to do is set this for one last plea date in December. If it hasn't settled, then the state will move forward for trial in April on the 7th.
All right, December 7th.
So we're not going to move forward on the fraud. We can draft an order
All right.
just to get it going.
Thanks, Judge.
Go back then to 2025 CR 55, State versus Paul E. Davidson.
Mr. Davis.
Your Honor, this is the case where we've had out-of-state witnesses, and the state has tried to get them here in any manner that we can. I filed a motion for Zoom testimony today, and I'm going to have to strike that motion. I went to the office, had a scheduled FaceTime call with the victim and his guardian yesterday at 6:30 p.m. I went to the office, I called them 3 times, was not able to reach them to prepare for today.
Well, I reviewed the motion and reviewed Mr. Clemens's response, and I have to agree with Mr. Clemens that there is a statutory scheme that would allow a child to not have to be in the courtroom to testify. But to my knowledge, there's never been a case where a victim, minor or adult, is allowed to avoid the in-courtroom confrontation by being in another state with and coming in on Zoom. We've had other witnesses who agree to be bound by the rules and by the statutory scheme of things, but when it's the victim in case, I don't see how that could take place. So I know you've made a good faith effort to try to obtain that child to be brought to the state of Tennessee. I'm aware that there is an issue, whatever. So what is the state's position? Set the trial tomorrow.
All right. We cannot move forward. I do want to file this order that came out of Brevard County, Florida. They had a hearing to serve, we did the interstate system. They had a hearing to serve the minor and his guardian. That judge, after testimony from the guardian, only served the minor. So I have that order. I want to put it in the court. There's no way for us to have him supervised or anything to bring him here.
Right.
We did try.
Ms. Clemens, this case is dismissed on the state's vote.
Oh, and I'm sorry, I'll have to redact the minor's name. Thank you, Mr. Clemens, and then we'll file that.
Thank you.
Yes, the state's gonna not leave this, but we tried everything we could.
And that was set for trial tomorrow, correct?
Yes, sir. That's correct.
Ms. Stevens,
Yes,
you
sir.
ready on your case?
Judge. Thank you, Your Honor. Let's do that second call. This is set for plea, Judge. We have a plea sheet and diversion form.
All right, I've been handed a document indicating Mr. Gordon's going to enter a plea of no contest or no contendere to count one that charge of theft of property. And he would receive a sentence of 8 years in the Department of Corrections as a range one offender, suspended to 8 years supervised probation, restitution of $107,118. Diversion would be eligible. There would be no contact with the victim.
That's correct, Your Honor. He's gonna make a $20,000 down payment on that today. That was the reason for the settlement. He was able to come up with such a.
$20,000 today, and then $1,000 a month until the remaining balance of $87,000 is paid in full. Restitution must be paid prior to the completion of probation and does not terminate state probation. Defendant must complete 8 years of state probation. A missed payment shall be considered a violation of probation. All right, Mr. Gordon, raise your right hand. Let's place you on the oath.
You solemnly swear affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Richard Gordon.
Mr. Gordon, you heard me go over what the agreement is today, but have you seen or been shown a copy of the charges and talked them over with Ms. Stevens? And you and she discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes.
Well, it's indicated you want to enter a plea of no contendere or no contest. That simply means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be. And I will use that evidence to find you guilty according to this agreement. However, this is being entered under a specific statute of 4035-313 because you have no prior record. That means that if you're handing me this plea, I'm going to order that you be placed on probation. If you successfully complete your probation, pay off the restitution in full, do everything you're supposed to do, don't have any new arrests, and at the end of that 8-year probationary period, you can apply to have your record expunged or wiped clean, and it will be as though this never occurred. You understand that?
Yes.
You understand it won't happen automatically. You'll have to apply for it after you've completed everything. You understand, however, that you have the right to plead not guilty and to have a speedy and public trial by jury in this court. You understand you would have the right to have a lawyer and have one appointed if you could not afford your own. You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Ms. Stevens could confront and cross-examine every witness the state calls to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of no contest, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes.
You understand that, as I've explained, if you're successful, this will stay off your record. If you're unsuccessful, you violate your probation, get arrested on some new charge, don't pay your restitution. This will become a permanent conviction on your record, and you can be and it can be used to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You also understand that under 4035-313, the judicial diversion statute, you're receiving the minimum sentence for a Class B felony. If you violate the terms of your probation, then you can come back into court, and a judge, myself or one of the others, could actually sentence you to a greater sentence than 8 years, but within the range of punishment for a range one offender. You understand that? That would only happen if you violate your probation. You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest according to this agreement and waive the right to a trial?
Yes,
Is your decision to plead no contest today voluntary?
yes.
Anybody forcing you to do this against your will? You understand, I cannot accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty of these charges. Then listen as the state tells me what their evidence will be with this case, Mr. John. Step aside, let General Allen step to the podium, please.
Your Honor, the state would put on proof that between December first of 2024 and March first of 2025, the defendant and the victim, Zane Mason, had contracted for him to build a house for Mr. Mason. He did a minimal amount of work by pouring the footers. Mr. Mason was unable to get the rest of the money returned by Mr. Gordon. But his ability to be able to pay such a large sum today did help settle this case. That's the facts that we.
I'm not asking you to agree with those facts, but you understand that's what the state's evidence will be if you went to trial.
Yes,
You still wish to enter a plea of no contest.
yes,
Are you satisfied with your attorney services?
yes.
I feel like Ms. Stevens has done a good job of representing your cause. Stevens, you know of any reason he should not enter this plea?
No, sir. No, sir. We have the cashier's check. Do I present that to your honor?
I'll tend to that to
Thank you, Judge.
Officer Burchett, Sergeant Burchett. It's now been handed to the clerk.
Thank you.
Anything further from the state? She stepped out, so I don't believe there is. Then in 2025 CR6, upon the plea of Mr. Richard Gordon to no contest to count one, I found him guilty and sentenced him to be placed on probation for a period of 8 years as a range one offender. He is ordered to pay restitution of $118,000. He's ordered to have no contact with the victim. He's ordered to pay the court costs. This will be entered under 4035-315. He is to pay $20,000 today, in which he had just handed a check for that, $1,000 a month until the remaining balances of $87,118 is paid in full. The restitution must be paid prior to the completion of probation. This does not terminate the state probation. The defendant must complete 8 years of state probation. A missed payment will be considered a violation of probation. All right, he needs to see probation.
Thank you. In your honor, as part of bond conditions, he has an ankle monitor, so that should be.
Take that.
That can be removed today.
Thank you, Judge.
On Peters, what do we have 11? This was it just this Sog,
And that is along with Bagel to Grad. They're together.
they're both together and
Yes,
they're
sir.
both for 11 o'clock. Then we have Robert Kaiser for sentencing hearing, correct? Let me take just a mid-morning recess and review that pre-sentence report before we get started. Robert Kaiser.
All rise.
We are now, Judge.
All right. General Allen, I have admitted, Kayla McDonald and Angela Hughes.
Yes,
Those are your two individuals.
yes. And then Miss Nancy and her family would like to sit up here so they can hear. That's okay.
We are ready for them to come on up.
Do we want to do the statements first or the plea first, Your Honor?
Let's do the plea first because the statement won't have any value unless it's the plea has already been entered.
Okay.
So,
All right, we're dealing with Peter,
but hold your grad, Your Honor.
the Joel crowd. Let's have him come up. I've been handed a document indicating that Mr. Crad is going to enter a plea of no contest or nolo contendere to count one criminally negligent homicide and E felony, and count two aggravated assault by reckless conduct of class D felony. And on count one, he is sentenced to 1 year suspended to supervised probation as a range one offender, credit for time served, waived fine and cost, and 2 years suspended on count two, 2 years suspended to supervised probation as a range one offender, concurrent with count one, credit for time served, waived the fine and cost, paying $1,625.92 in restitution to Caleb McDonald, joint and severable with Benjamin Sogsog. The under the law, he may apply for judicial diversion. So, all right.
And Your Honor, the waiving the fine costs so that they could focus on restitution.
All right. If you'll raise your right hand and let's place you under oath, please.
Do you solemnly swear from the testimony you provide will be the truth, the whole truth, nothing but the truth, so help you God?
Thank you. If you'll move that microphone where you can make sure we pick them up. State your full legal name for the record. All right, and I'm going to spell that. Is it Fagalchugrad? All right, then I may mispronounce that throughout this whole thing, and I apologize for that, but I'll do the best I can. You are here today charged with 2-count indictment, actually a multi-count indictment. And it's been indicated that you're going to plead a no contest or enter a plea of no contest or nolo contendere to 2 of those counts. The remaining counts would be dismissed against you. A plea of nolo contendere means that you are not going to admit you did anything wrong, but you're not going to contest the state's evidence against you, and that evidence will be used by me to find you guilty according to this agreement. You understand that? Now, it's been indicated that you may apply for judicial diversion. That's entirely up to the Department of Corrections. The Tennessee Bureau of Investigation. They will have to do a background check, and they'll have to determine whether or not you can or cannot be eligible for that diversion. But if assuming that you are, then you would be granted this diversion, which means you'd be on probation for the entire time. And at the end of that, only if you have successfully completed all the terms of your probation could you apply to have your record expunged. Do you understand that? Yes. Do you understand that you have the right to plead? First of all, do you understand everything you're charged with, and have you and Mr. Clemens discussed the range of punishment you're facing as well as any possible offenses? Do you understand you have have the right to plead not guilty and to have a speedy and public trial by jury in this court? Yes. You understand if you plead guilty, you would have the right, or pled not guilty, you would have the right to have an attorney, to have one appointed for you if you could afford your own. Yes. We've done that, of course, with a public defender. You also understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state might call to testify against you, and you could bring in your own witnesses by the use of a subpoena. You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you were at trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that, in other words, if you went to trial and the jury found you guilty of anything, you would have the right to appeal that to a higher court, a court of criminal appeals. And you would have the right, because you're indigent and unable to afford your own lawyer, you would have the right to have an attorney appointed to help you with that appeal. You understand that? You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer and the state and the victim's family have all agreed to. You understand that, as I explained to you, these will become permanent convictions if you do not comply with the terms of this agreement. If you don't complete your probation, you don't pay the restitution that's been indicated, you get arrested on some new crime of any kind, then the state will ask them that your judicial diversion be revoked, and it will become permanent convictions, and that could be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand all of that? You understand everything I've explained to you?
Yes.
You want to plead no contest to these charges according to this agreement. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty. And I want you to step aside and let General Allen come to this podium and tell us what the facts would be if the state went to trial.
Your Honor, these would be the same facts for Mr. Salzog as well. Is that okay?
Yes.
The state would put on proof, Your Honor, that on July 1st of 2023, in the afternoon of that day, on the Kentucky Lake in Stewart County, there was an accident between two jet skis. One of those was operated by Mr. Fagelchagrad. There was a minor child, the age of 11, who was the child of Mr. Salzog, in the front of the jet ski. Roy Heron and Kayla McDonald were on another jet ski. Under the law, if there is an adult with a child under the age of 12 on a jet ski, they are supposed to be able to reach the handlebars and take control of that jet ski. And Mr. Fagelchagrad was not able to do that. So we charged him with criminal responsibility when their jet ski crashed into Roy Heron's jet ski. Roy Heron eventually, he suffered major trauma to the brain, and he eventually succumbed to those injuries and died. Miss McDonald had severe injuries. She was paraplegic for a while, had a fractured pelvis, and she missed a year from school because of that. And we also charged the owner of the jet skis for allowing a minor to be on there that wasn't the age of 12. So these are both charged with criminal responsibility.
All right. When you will do correct, you'll come back. I'm not asking you to agree with those facts, but you understand that's what the state's evidence will be if this case went to trial. You still wish to enter this plea according to this agreement?
Yes.
Are you satisfied with your attorney services?
Yes.
I feel like Mr. Clemens has done a good job of representing you confidently. Mr. Clemens, you know of any reason you should not enter this plea?
No.
All right. Then before I pronounce sentence, we have a victim impact. And I think that we want to let the state have that. So let's have Mr. Clemens, if you and your client will move over out of the way and let.
Do we want to announce Salzog first too, or let it go after?
Let's do Mr. Salzog as well.
Morning, Your Honor.
Good morning.
Mr. Salzog is present. His wife is also in the audience. If I may hand forward, Your Honor, there's a complete petition, and then also for now, I'm going to tender the certification concerning diversion.
All right, I've been handed a document indicating that Mr. Salzog is going to be entering a plea of no contendere or no contest to count 2, contributing to the delinquency of a minor, and count 4 and 7, accessory to a violation, and count 6, watercraft owner not to allow a violator. His punishment would be 2 Class A misdemeanors and 2 Class C misdemeanors, 11 months to 29 days with 30 days concurrent, suspended to either probation or diversion, as determined by the court. restitution of $1,625.92 to Caleb McDonald jointly and severally with the co-defendant. And the defendant must complete a voter safety course. All right, Mr. Sox, raise your right hand. Let's break you under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God? Yes, sir.
State your full name for the record. We are taking down everything that's being said here today, so we need to make sure that you speak up loudly enough for it to be recorded and for my court reporter to hear what you're saying. You are here today and you heard me go over what the agreement is, but have you seen or been shown a copy of those charges talking over with Mr. White here, and he discussed the range of punishment you're facing as well as any possible defenses you might have? Do you feel like you understand what you're charged with?
Yes, sir.
You understand that you're entering a plea of no contest, and you may have heard me say a plea of no contest is a plea that says, I'm not going to admit I did anything wrong, but I'm not going to deny what the state's evidence or contest what the state's evidence would be, and their evidence will be what I use to find you guilty according to this agreement. You understand that? You understand what you're charged with, and do you understand you have a right to plead not guilty and to have a speedy and public trial by jury in this court? You understand if we had a hearing or a trial, you would have the right to have a lawyer and have one appointed if you cannot afford one. Of course, you have Mr. Alford here on your behalf. You understand that at trial you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Alford could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that in trial you'd be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. It would just be me approving what your lawyer and the state and the victim's family have all agreed upon. You understand all of that? Now, it's been indicated that you as well may apply for judicial diversion, and you've been approved by the state. What that means is that you're going to be on probation for the period that's been set forth. If you successfully complete everything that you're required to do as a part of your probation, including the payment of restitution and the completion of this voter safety course, then you can apply to have your record expunged or wiped clean at the end of that time. You understand that? It will happen automatically. You'll have to file a motion with the court to have that done. Do you understand everything I've explained to you thus far? Now, if you don't complete the terms of that probation, or you don't qualify for the judicial diversion, then you commit a new offense, these will become permanent convictions, and they'll be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand that? Right. Do you wish to plead no contest according to this agreement and waive your right to a trial? Gotta say yes.
Yes.
Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty of these crimes. Now, you were present in the courtroom and you may not have heard, but are you familiar with the factual basis that the state gave for me as in the prior case with your co-defendant? Did you hear everything that was said?
Yes.
Right. So you understand that this is resulting from you owning the watercraft and allowing your co-defendant to allow a minor child to operate it without the proper statutory compliance. You understand that? That resulted in an accident that inflicted injuries upon Ms. McDonald, as well as injuries upon Mr. Heron that caused his death. You understand that? All right. Then I find that the statement of facts that was given in Mr. Gildjacrad's case should be sufficient for this. Are you satisfied with your attorney services? You think Mr. Humphreys has done a good job of representing you in this case?
Yes.
So Alfred, do you know of any reason he should not enter this court?
No, Your Honor.
So let's have him have a seat over here, because I'm gonna have his, victim impact presented before I pronounce sentence in both of these cases.
Miss Angela Hughes is going to speak. I have,
Ms. Hughes, can you hear everything that we've talked about?
Yes, sir.
We're gonna go ahead and let you make your statement. Thank you.
Thank you very much. Good morning, Judge Wolf and members of the court. My name is Angela Hughes. I'm the mother of the victim, Kayla McDonald. On July 1st, 2023, I received the most dreaded call a parent could ever get. There's been a boating accident involving your daughter, and you need to get here. I knew it was bad when I heard the chaos in the background. I just wanted to hear my daughter's voice as she had collapsed and slipped in and out of consciousness. I dropped everything and flew to Tennessee to be right by her side. Emergency surgery to put her broken pelvis back together. As I questioned the surgeon, would my daughter ever be able to bear a child? In addition, she suffered broken bones in her back, a spinal cord injury, broken rib, lacerated spleen, liver, and kidney, internal bleeding, shredded muscles, and excruciating pain. Days in ICU, fall risk hospital rooms, and over a month in rehab to learn how to walk again. When she was finally discharged from the rehab center, she had a total of 17 prescriptions to aid in her recovery. Later in October of 2023, my daughter suffered a setback and was rushed to the hospital, only to discover she had developed a hole in her kidney that caused an abscess infection due to the accident. Therefore, she had to undergo yet another surgery and spend more time in the hospital recovering. In addition to her physical injuries, the psychological effects, PTSD, having to sit out a year of school, as well as survivor's remorse, cuts just as deep. As we know, the other person on the jet ski with her, affectionately known as Uncle Roy, is no longer here with us today. Unknowingly, Roy served as my daughter's guardian angel that day by physically shielding her, as you struck him first, and he bore the brunt of the hit. To have to say goodbye to Roy was heartbreaking for her, and he will always be in our family's heart for the hero and protector he was. As a recovered paraplegic, my daughter is much stronger today. However, her body will never be the same. There are 4 screws that hold her pelvis together. She continually suffers from hip and back pain, stiffness in her joints, and can no longer walk as fast-paced as before. The nerve sensations in her legs are different now, and her athletic endurance has lessened. The decision made to allow an underage child to operate a jet ski was a poor one. It caused a loss of life, the loss of a husband, father, brother, uncle, family member, and loved one. Roy should still be here. My daughter should not have these health ailments that will plague her for the rest of her life. And on behalf of my daughter, who is still traumatized and chose not to speak today, I am speaking for her, loud and clear. This accident could have been avoided and should never have happened. I hope and pray you understand the immense pain you have caused to both our families and that you have remorse for what happened that day on the water. Thank you for your time.
Thank you, Ms. Hughes. We have another statement.
Miss Nancy Herring.
My name is Nancy Miller Heron. I am the widow of Roy Heron, who was mortally injured in the jet ski collision we've been discussing today. My son, Ben, who was at the time a medical student at Emory, had invited a group of his friends to the lake to celebrate the 4th of July. Ben and his friends were on a pontoon boat just yards away when the jet ski piloted by an 11-year-old boy plowed into the jet ski where Roy and Kayla were idling. Jet ski hit Roy in the head, causing what would prove to be fatal injuries for him and seriously injured Kayla McDonald. Ben and his friends on the pontoon boat saw the collision and rushed to save Roy and Kayla. They pulled them from the water, administered first aid and CPR,
and rushed them to the dock where they hoped an ambulance would be waiting. Ben encouraged those on the other jet ski to get into the pontoon boat so they could go to the hospital and be checked for injuries. Ben called me, screaming about the roar of the pontoon boat's motor, begging me to arrange for a helicopter to meet them and take Roy and Kayla to Vanderbilt. He kept saying, it's so bad, it's really, really bad. Eventually, Roy was airlifted to Vanderbilt Medical Center and Kayla was taken there by ambulance. Roy spent 9 days in the trauma unit. He died on July 9th, 2026. As Kayla's mother has already said, Kayla suffered fractured bones, internal injuries, endured multiple surgeries, months of rehab, and she still endures pain even to this day. Kayla McDonald is literally the bravest person I know. Roy's absence has been deeply and profoundly felt by me and our 3 sons, John, Rick, and Ben. Our immediate family has suffered from the trauma and PTSD that comes with a sudden violent death. Both Kayla and Ben still suffer from survivor's guilt. Loss has also been felt by Roy's brother, Ben, along with my son, Rick, who's here today, along with Roy's entire extended family, including cousins, nieces, nephews, in-laws, and by his many, many friends across the nation. Roy Heron was a force of nature. He was a devoted family man who never gave up on the people he loved. He was an attorney, a public servant, a writer, a teacher, and mentor. He was even an Ironman triathlete. He lived a large life. While in the legislature, Roy fought to make health care available to all Tennesseans, and he sought always to protect children, the working people of Tennessee, and those who were disadvantaged. As his longtime friend Joe Hill said, Roy's advocacy for the least of these is also his legacy. Since Roy's death, literally dozens of people have approached me with stories of the difference Roy made in their lives. Stories of how Roy helped a family member get health insurance that literally saved their life, or helped a young person get into college, or helped a person he barely knew get a job. Many of these stories even I had heard. So the loss to both our families is vast and deep. Since Roy's death, my family and I have worked to get the minimum age for driving a jet ski without supervision raised. This year, we were able to get it raised to 14. We are also advocating for a requirement that jet ski owners have liability insurance, just as drivers of cars are required to, so that those injured, like the brilliant, elegant, and compassionate Kayla McDonald, would have more help and can be compensated for their pain and suffering. Going forward, we hope to raise awareness of just how dangerous jet skis can be. Now I'm speaking only for myself and not for anyone else. Recently, a lifelong friend sent me a copy of a letter Roy wrote to her in 1999. In this letter, Roy said that a friend from college had just lost 2 of his daughters in a terrible train wreck. Roy said his friend Matt had already forgiven the truck driver whose actions caused the wreck that killed his daughters. Matt said, "There are no mistakes that we make that are outside of God's grace. God forgives him, and we forgive him too." In his letter, Roy said of his friend Matt, "Talk about a faithful response." I know that Roy would want me to have the same faithful response. I do believe there are no mistakes that we make that are outside of God's grace. With regard to the boy who piloted the jet ski, neither I nor anyone in my family holds a ill will toward him. He was 11. But I also want Mr. Sodsog and Mr. Bagalcharat to know that I forgive them. I don't want the events of July 21, 2023 alone to define their futures.
Right. sometimes there are tragedies that occur in life for which there is no good solution or no good way to fix the problems, and this is one of those. I knew Mr. Herron slightly. I met him on occasion when he was running, I think, for the Public Service Commission, or he was running for public service, public office before. I knew he was an attorney. He's better friends with some of my friends, but I met him on occasion. I think we wrote a book at one time, and I was around for some reception about that. He was a fine individual, and his loss will be something that we'll all regret for some time, and his loss will never be something that can be made whole with his family and his friends. The same way, Miss Kayla has suffered an immense injury that there is no good way to fix. And having had a few minor surgeries, I can only shudder to think about what you've had to go through, Kayla, and what the problems that you had in the past and the future that you have ahead of you when you continue to deal with these situations. I'm sorry we don't have a better solution to fix all of this. But as far as these defendants go, Mr. Sogsog and Mr. Fajul Dukrad, you need to understand one thing, that is, this family has forgiven you. And that may be the only reason that you're not facing more severe punishment than what is being done. They are compassionate towards the young boy that was placed in this position. And I do think about him and what he has to go through, what his negligence or his inability to control that watercraft caused for Miss McDonald as well as for Roy Herron. And it's just a tragedy all the way around. The responsible parties have, before this court, entered a plea, and this court will hold to that plea because I think it's the best solution that the family and the state and the defendants have all agreed upon. So, as to Peter Fajul Akrad, on docket number 2025 CR 31, upon his plea of no contest, I found him guilty and ordered him to be sentenced on count 1 to 1 year to the Tennessee Department of Corrections that will be suspended to supervised probation as a range 1 offender with credit for time served. He'll fines and costs are waived. Count 2, aggravated assault by reckless conduct. He is sentenced to 2 years Tennessee Department of Corrections. That will be supervised probation. It will be concurrent with count 1 with credit for time served. The fines and costs are waived, but there's $1,625.92 of restitution to Caleb McDonald. That will be joint and several with Mr. Benjamin Sogsog. And that is entered under 4035-313. If he is eligible for diversion, then that will be entered under that statute. Mr. Sogsog is found guilty of contributing to the delinquency of a minor. In each of those cases, is 2 Class A misdemeanors. He's sentenced to 11 months and 29 days in the county jail. That would be 30 days on the 2 Class C misdemeanors, all of which will be concurrent and suspended to probation. He's applied for and been cleared for diversion, so it'll be entered under 4035-313. He is ordered to pay restitution of $1,625.92 to Caleb McDonald, again jointly and severally, and he must complete a voter safety course. Both of these individuals need to understand that even if they are cleared for the judicial diversion, until they have paid the entirety of their restitution and completed their probationary period, and then all of the terms and conditions of that, they will not be eligible for expungement. That is judgment. Ms. Kayla, I'm sorry for what you've been through, and I know you've got a long road still ahead of you, but I admire your courage and your fortitude to keep going in the right direction. You're lucky that you have a mother like you do for Miss Hughes to stand up for you and to be there to support you. And the Herring family, I'm sorry for your loss. I wish there was more I could do to offset that. But I admire your spirit, and I admire your courage, and I admire your forgiveness. So that will conclude this hearing. They both need to see the probation report.
No, but me,
You may.
that's just, please, Your Honor, we have the diversion certificate.
What we have left is State versus Robert Kaiser.
Yes, Your Honor. State's ready on that.
Judge, oh, sorry. You ready, Your Honor? I don't want to interrupt you.
That's all
I've got Dewey Robinson here, here to report, subject to the court's approval. I think we need to reset that to December. State apparently believes there might be new evidence. I do think it will resolve the plea, so I don't think it was set for jury trial tomorrow.
Right, and I think the state told me they were not opposed to resetting it. I think December the 7th would be the right one. December 7th.
December 7th, Your Honor. Thank you. Thank you.
All right, we're ready for the sentencing hearing with Robert Kaiser.
Yeah.
One of my sack trees is back there in the office. Would you bring that to me? Yes, all right, so state ready?
Yes, Your Honor.
Defense ready?
Yes, Your Honor.
Right. This is the state of Tennessee versus Mr. Robert L. Kaiser for sentencing hearing in docket number. This one is 2023 CR7. All right, state, I call you first witness.
Civil call Wendy James. Sorry, it's been one of the days. Well,
You have to turn her microphone on. So.
Deep breath, raise your right hand, face there.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
please state your name for the record.
Wendy James,
And where are you employed?
City Department of Corrections,
And what is your job?
recent investigations.
And what is a pre-sentence investigation?
I request an NCIC and enter all criminal information. I do an interview with the defendant, determine the risks and needs. Contact victims if necessary.
And in this case, did you meet with Mr. Kaiser?
I did.
When did you meet with him?
Was May 18th, 26.
And did you ask him about this case that he was convicted of by a jury?
I did.
Okay, what was his response to that? I think it's on page 4 of your pre-sentence report. Did he admit or deny
He
Regarding this guy?
said that he did not know that the gun was in the vehicle.
But regardless, he was convicted of lawfully possessing a weapon.
Yes.
Now, what did you find out about Mr. Kaiser's criminal history?
He has 24 misdemeanor offenses and 8 felonies.
Those are all convictions.
Yes.
So he has pretty extensive criminal history.
Yes.
And how many times has Mr. Kaiser been placed on probation or parole and been successful completing a sentence without being violated or revoked?
He successfully completed on 4/11 of 25, and then there were 4 other convictions where he was placed on community corrections or probation that he revoked. I think there's 6 revocations altogether.
So he doesn't have a great history of successfully completing any kind of final sentence.
No, just the last
The
one.
last one. And the very, this case, he was charged with this in 2021. One he was convicted of. Did he continue, based on his criminal history, did he continue to pick up charges, get convictions after 2021?
I had 6 convictions after 2021.
Were those misdemeanors, felonies, or both?
1 felony, 5 misdemeanors.
And he still has some pending cases, is that correct?
Correct.
And on the very back page, this assessment right here, can you explain that for, what does that mean?
That is the risk and needs assessment.
Okay.
I ask him questions and then I enter his responses into the system and it gives me a risk score, and the risk is for reoffending.
Okay.
He scored high risk for reoffending. And then the needs section is where he may need help controlling certain things, and he scored moderate in the aggression.
Your Honor, I'd like to pass up this pre-sentence report.
I will mark it as exhibit 1.
Not pass for this, Your Honor.
White, you may cross-examine.
You went to the jail and interviewed Mr. Kaiser, is that correct? Were you guys face to face? Was there a barrier between you?
No.
Was he courteous to you?
Oh, yes.
Did he make any threats or anything like that against you? Was it personable?
Yes. It was.
No further questions, Your Honor. Thank you.
Thank you, ma'am. You may sit down. State may call your next witness.
No further witnesses.
State has rested their proof, Mr. White. Do you wish to offer any proof?
Your Honor, my client would like to do an allocation.
All right, he may come to the podium and make his allocution.
I'll stand behind you. Mr. Kaiser, would you want him at the lectern, Your Honor, or at the?
Well, just have him, yeah, he can come right here. Just have a seat. He's not gonna, if he's making an allocution, he doesn't be sworn. The allocution is where the defendant can make a statement on his own behalf, but it's not sworn testimony.
Correct.
Okay, let's see how to start this. Yeah, Your Honor, I think I deserve a chance on community correction, so, to prove it, because the last probation I was on, actually Larry Wallace gave it to me. He gave me high risk, I guess, because I was mandatory drugs thing every month. This was for 2 years, and I passed every one of them. I didn't miss no appointments. I didn't do anything. I had a lot of things going on in my mind. I lost my mom, I just lost my dad and my first cousin. So it was, at the time, I was asking for help, but no one wanted to give me help, So Larry Wallace put his faith in me one time and I proved that I could do that. I mean, I'm not minding for community correction or nothing, but I thank my family. I got 5 kids. I ain't, I'm 56 years old. And this is a 5-year-old case, which I was actually placed on probation after I caught this case. The DA gave me probation on another case in Houston County that was actually supposed to be after this case, but they kept putting it off here in Stewart County for months, but Houston County said they couldn't allow it to be put off no more. That's the only reason it was put off for like 5 years, because they didn't want to, Stewart County didn't want nothing to do with it. So all I'm saying is, y'all, if you give me a chance on community correction, mandatory drug screens, house arrest, or whatever, that I feel like I can pass it. I don't, that used to me, I was different when I was young and stuff, so it's what's come back to haunt me now. Things I was doing as a younger man, but I got kids to say, and one grandbaby on the way, and I would really appreciate to show you, and of course, that I can do community correction, house arrest, or whatever, of course, often. I don't think I can last 10 years or nothing like that in prison. It's not cut out for me no more, so that's all I'm asking.
All right, thank you. Step down.
Yes, sir. Thank you.
Mr. White, you have any other proof?
No, Your Honor.
I'll hear you an argument.
Yes, Your Honor. Your Honor, the state filed a notice of enhancement impeachment of Mr. Kaiser in this case back in April of 2025, based on his prior felony convictions. And we would be asking this court to sentence him as a range 3 offender on this class C felony, lawful possession of a gun by a convicted felon. And under 4035-501, I think it's section Y. Section Y1A. For this offense particularly, offenses occurring after July 1st, 2021, which I believe this offense did occur after July 1st, 2021. It's an 85% sentence here. So it's 10 to 15 years and 85%. And based on his prior criminal history, it's well documented in his pre-sentence report. He's only successfully completed probation once in his entire life. That was for a 2-year sentence. All the other times he has failed to complete any type of supervised probation. It's the state's position that Mr. Kaiser has a long history of convictions for felonies and misdemeanors. He is not the type of person to be placed on supervised probation. This period, he's had plenty of chances in his life to get his life straightened out, and he has violated. I would say 95% of the time while he's been on supervised probation. And based on that, the state will be asking this court to sentence him to 15 years, 85% on this class C conviction.
Mr. White?
Yes, Your Honor. Your Honor, mitigating factor number 1, nobody got hurt, and nobody was threatened to be hurt. There was no even criminal negligence of anybody being at high risk of harm. The man was driving home, he got pulled over, he was cooperative with the officers, and they found a gun. Now, I believe that under mitigating ground number 3, there is still a presumption that even though he's responsible for what's in his vehicle, he might not have known that the gun was in there. I mean, I can't imagine that a seasoned veteran would sit there and let somebody search their car just because the cops asked if he knew there was a gun in there. And he was casual and he was calm the whole time, and he had a trusting relationship with the officers. It wasn't like he was detained in the back of the car. He wasn't throwing a fit. He was just being a citizen responding to the officers and trying to get along instead of going. This case is most likely going to at least go to a certain. My mind is not with me today, Your Honor. I apologize. My words leave me a little bit, but There is going to be a motion for a new trial and potentially even a late motion for acquittal since the case is still pending. The case has a procedure, has some interesting postures when it comes to the law because he was detained on a warrant out of Stewart or Houston County that they didn't come collect him on, which reads very similar to State v. McElrath. Now, we will argue this another day, most likely in December, Your Honor. However, I do ask, and I always ask, that just because a man proclaims his innocence or states a fact doesn't mean that he's not taking responsibility. I believe it gets confusion in courts. We do not deny that the jury of 12 came back and found him guilty. There's no denial of that. We were all here. We all saw it. However, I don't believe a man should be sentenced in a greater capacity because he's sticking with his innocence in a plausible story as well. This isn't some fantastical, like, Rainbow Sherbert placed the gun in there. This is a matter of, there is a possibility, considering where the handgun was and considering Mr. Kaiser's statements, that he did not know that gun was there. Now, that's a question for either the court to revisit on another date or for the appellate court to revisit. However, again, I have to press that the court is guided to give him the least restrictive sentence possible. And in this matter, I do agree that he is a range 3 offender. So I think that the 10 to 15 range is appropriate. The nature of the offense is a 100% mandatory, I believe. Well, it's 100% offense, 85%. However, I don't believe that sentencing a man to 10 years over a gun that he may or may not know is still extreme. Mr. Kaiser obviously doesn't want to go to prison for that long. But at the same time, the court's got their hands tied to a limit. I know State v. Hicks allows you to plead out of range. We would ask for a deviation downward 1 level, putting him in this, I believe, 6 to 10 range, Your Honor. And I do believe community corrections, if available, would be great for him to be on that hybrid supervision. He's shown that even though in the past he had trouble dealing with maintaining probation, he has completed one since then. 2 years is a long time to keep your nose clean with somebody like Mr. Kaiser's record, and apparently he completed probation, which is an accomplishment. It's not an easy thing to do. We see people fail every day. So, Your Honor, we would ask that he be given a minimum sentence, that we court recognize that there is still a question there as to whether he knew, even though the jury found him, and that he be given a range 2 offense, maybe a 6 to 10 range. 6 years, Your Honor, would still be a long time to serve for a status offender possessing something he shouldn't. Thank you.
Willow?
There you
go. The court is always required, excuse me, in one of these cases where I have to impose a sentence, I'm required, I cannot just set the sentence that maybe I would like to set or one I thought would be appropriate. I have to follow the sentencing guidelines that are set forth by state legislature, and those are all set forth in the Tennessee Code. And I will start with the sentencing considerations in view of what Mr. White has been arguing under 4035-103. Our state legislature says to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. According to the testimony of Officer James and the pre-sentence report, Mr. Kaiser has 31 prior convictions, 8 felonies and 24 misdemeanors. Confinement is necessary to avoid depreciating the seriousness of the offense, which I don't really find that would apply. Measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. And in this case, he has previously been placed on probation. I think it is that he has been on probation, and there were 6 violations of probation according to the testimony of Officer James. So I found that obviously would factor in. The sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences are related to the purpose of the chapter should be avoided. Sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. That's that is, I assume, what Mr. White was referring to when he used the term that the court should impose the least restrictive sentence possible. But this court's job is not to impose the least restrictive sentence possible. Its job is to enforce the law and to protect society from someone who repeatedly violates the law. The potential or lack of potential for the rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or the length of term imposed, and other factors that are set forth in that statute. First consideration that the court must look to is to determine what is the range. The state has filed a notice of enhancement setting forth the 8 felony convictions which this court finds under 4035-107. Mr. Kaiser would be considered to be a range 3 offender because he has 8 prior felony convictions. This is a Class C felony that he's been found guilty of here. And under 4035-107, subsection A1, a persistent offender is a defendant who has received any combination of 5 or more prior felony convictions within the conviction class or higher, or within the next 2 lower felony classes where applicable. And in this case, all of his prior convictions are Class C's and Class E, or actually he's got some Class B, I think. So all of those would qualify under that 4035-107. So therefore, Mr. Kaiser is a range 3 persistent offender under the law. And generally, I mean, it may be that I could somehow find some justification, but the mere fact that he doesn't want to serve time in jail or prison is not a factor that this court can consider in deciding what the sentence should be. So having set his sentence range, which is 10 to 15 years, and it would be at 85% as a range 3 offender, then I must look to see what the range of sentence should be imposed. And those are set forth by the mitigating factors and enhancement factors. Mr. White argues that the defendant's criminal conduct neither caused nor threatened serious bodily injury, which I would say that is correct. Although you're driving on a revoked license, the argument can be made that anyone drives on a revoked license is potentially causing or threatening bodily injury to other people who are on the roadway. I do find that first mitigating factor would apply. Substantial grounds exist tending to excuse or justify the defendant's criminal conduct or failing to establish offense. Mr. White argues that Mr. Kaiser's argument at testimony at trial was that he didn't, or his position at trial was that he didn't know the gun was in the vehicle. The gun, he stated, according to my recollection, to the officers that gun would have his fingerprints on it. The jury considered that testimony and they disregarded the defense as saying, I didn't know it was there. So I have a jury that finds that he was guilty of possessing that weapon. So I do not find that number 3 applies. And none of the other mitigating factors that I've looked at have any application to this case. The enhancement factors are 4035-114. And those are, number 1, the defendant has a previous history of criminal conviction or criminal behavior. In addition to those necessary to establish the appropriate range, and he certainly does. As I stated, this goes to show you there are 8 felonies and 24 misdemeanors, and I said there were 31. There are 32. The reason I didn't go to become an accountant, I can't add. But there are 32 convictions. Of those, only 5 of the felonies were required to qualify, and 24 misdemeanors. Obviously, it shows an extensive disregard for the laws of the state of Tennessee. And a lot of these are having to do with drug cases, driving on a revoked license. Multiple times he's been convicted of driving on a revoked license. Guess what? That's what this one is about too. There were multiple times that he drove while his license was revoked. And other than that, he also had drug cases, some of which were felony and some of which were misdemeanor. Looking at the enhancement factors, I do not find, other than number 8, which potentially the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release of the community. Clearly, 6 violations of probation where he was revoked to serve would be a factor. Number 9, he possessed or employed a firearm, explosive device during the commission of the offense. I don't think that can apply because it's the element of the offense of possessing the weapon that would apply. So at this point, the court finds that there is at least one enhancement and one mitigating factor. So for that reason, the court is of the opinion that your appropriate sentence would be on a count 1, which is the Class C felony. He was found guilty of possession of a firearm by a person having previously been convicted. And this court is of the opinion that the appropriate sentence would be 12 years in Tennessee Department of Correction. The next count was a Class B misdemeanor, driving a revoked license. He is sentenced to 6 months in the county jail. Class A misdemeanor of drug paraphernalia, he is sentenced to 11 months and 29 days in the county jail. Class C misdemeanor of seatbelt violation, this court was ordered to pay a $50 fine and costs. The court has considered his request to be placed on probation. This court is of the opinion that he is not likely to be successful in being on probation because of the simple fact that he's had 6 violations of probation. So this court sentences him to serve the sentence of 12 years in Tennessee Department of Correction. And judge will report.
Just for clarification, all these counts when they concur.
Concurrently, all of the counts run concurrently. That concludes our business for today, and therefore we stand adjourned.
All right.
Yeah.
You still should be able to get in. They asked me, come on, brother. They sit there and told me about it. I was like, I'm paid. I can eat all that.